Okay, this is a presentation by Mark Allenbaugh. It's an introduction to the federal sentencing guidelines and more specifically, federal sentencing statistics. This presentation is proprietary and confidential and not intended for public distribution or reproduction without my express authorization. The Essentially what I'm going to cover during this presentation is first begin with a short overview of the federal sentencing guidelines and the U.S. Sentencing Commission and how those operate, and then discuss statistics and how those can be used for purposes of advocacy at sentencing, be it by a criminal defense attorney or a prosecutor or even the court, and why these are statistics are so important today. So first off, there are approximately 3,000, actually over 3,000 federal statutes that criminalize conduct. Everything from murdering the president to committing wire fraud, child pornography offenses, money laundering, tax evasion, and a whole host of other things. The federal sentencing guidelines were created back in 1986 by the Sentencing Reform Act of 1984, and they went into effect on November 1, 1987. That act also created the U.S. Sentencing Commission. That is an independent agency in the judicial branch that its purpose was initially to promulgate the sentencing guidelines and now amend them and update them every year, depending on feedback that the commission gets from the public as well as courts that utilize the guidelines, and quite often from Congress. Congress has the ability to direct the commission to amend the guidelines in particular ways. Those are called, not surprisingly, congressional directives. At any rate, prior to 1987, when the guidelines went into effect, courts were able to sentence pretty much wherever they wanted to, up to the statutory maximum for whatever penalty there is. So, for example, wire fraud, and now it has a 20-year statutory maximum penalty. A judge could sentence wherever he or she thought was reasonable within that range. The problem was, as many jurists, practitioners, and legislatures soon discovered, or had long known, but it started to grow through the 70s and early 80s, was that there was wide disparity in the sentences. The sentences that were imposed by the federal judiciary seemed to be ad hoc. Somebody that committed a $50,000 fraud in one part of the country would get quite a bit, would get a very different sentence in another part of the country, depending on the judge. There was also some issues and concerns regarding race, whether minorities were getting penalized more for the same conduct that white defendants had committed, and a variety of other reasons, or a variety of other issues too. So what the guidelines were intended to do was address, first of all, that unwarranted disparity, to make sure that similarly situated offenders were treated similarly. So it really didn't matter what judge you had or the color of your skin. If you committed a similar offense, you should get approximately the same sentence anywhere in the country in front of any judge. That also helped to ensure more certainty in sentencing. Obviously, if sentences are really ad hoc, nobody really knows what kind of sentence they can expect. If they were just deciding to plead guilty or go to trial, be all over the place. So guidelines help with that as well. And then the third thing that the guidelines do assist with is proportionality, to ensure that defendants that commit certain type of conduct receive a sentence that is sufficient but not greater than necessary. That's actually statutory language. Sufficient and not greater than necessary for purposes of sentencing, that they're getting just the right amount. And sometimes that means that the sentences traditionally may have been too high in some areas, And for example, in white collar areas, there was a perception that sentences were too low. So the guidelines had initially were calibrated to raise slightly the average sentence there. Since 1987, when they were first went to effect, the guidelines have been amended over 800 or nearly 800 times. Before 2005, interestingly enough, they were mandatory. The sentencing guideline is not an actual number, but rather a small range. Just as an example, 41 to 51 months might be the guideline range in a particular case. So before 2005, if the guideline range was 41 to 51 months, the judge was required to sentence within that range, except under very, very limited circumstances. The judge could either depart above, which was called upward departure, or below, a downward departure. The judge pretty much had unfettered discretion to sentence anywhere within that range. 2005, the U.S. Supreme Court, in a case called Booker versus the United States, held that it was unconstitutional for the guidelines to be treated in a mandatory fashion, and thereafter, the Supreme Court said that the guidelines were merely advisory. So today, judges are not required by law to sentence within the guideline range. They can what's called vary. It's a new term of art that was created by the Booker decision, and variance is pretty much indistinguishable from a departure. Basically, they could vary below the guidelines, which means sentence below the guidelines, or vary above the guidelines. Since that time, since their discretion was increased as a result of Booker, judges for certain offenses, and we'll see this later in the presentation, have really exercised their discretion, have sentenced very often below the guideline range, or exercise what's called their Booker discretion to sentence below that range. So this has created a bit of a conundrum. The late Justice Scalia recognized this in a dissent that he filed in the Booker case, stating that if the guidelines are just merely advisory and judges are not required to follow them, then doesn't this get us back to the pre-guideline era where there really were no guidelines? And it's true, and that pretty much has happened to some degree, and it is that. But in some sense, without getting into too much detail, I personally think it is worse than it was prior to the guidelines, because now you have some judges that give weight to the guidelines, sentence within the guidelines, other judges that treat the guidelines somewhat with some weight, and other judges that completely disregard the guidelines. And that has just led to an additional level of complexity and, frankly, arbitrariness, which has increased the amount of uncertainty at sentencing, and proportionality is kind of all over the place. So the reason why, and just hitting this right now, that statistics are important is because when the guidelines were first promulgated, what the U.S. Sentencing Commission did is went back and looked at 10,000 cases. And that's back in 1986, there were not nearly as many federal defendants sentenced annually as there are now. But the commission went back and looked at 10,000 sentences and collected data and statistics off those sentences to create the initial promulgation of the guidelines. So they were born out of statistics and looking at what the median sentences were, the average sentences, as well as what factors judges in certain cases were identifying as important to them. So now what we can do is look at the statistics or the data that the commission collects every year, and the commission collects data on approximately 80,000 defendants each year, and a very robust data set in that regard is available online for practitioners to utilize and review. At any rate, so the point simply is this: the statistics now can be used to supplement guideline arguments to give courts a much more accurate assessment of what other courts are doing by and large in similar cases. And sometimes, and as we'll see, it's also important to compare dissimilar cases. And that helps to determine relative proportionality or the seriousness of a particular offense. So basically, what we can do now with the statistics that the Commission has collected over the last 30 years is basically recalibrate, if you will, for the courts the guidelines. And this is, Your Honor, this is really what the defendant should get. So, okay, let's talk about quickly what the guidelines look like. Here, this is just the table of contents for the federal sentencing guidelines. It's about a 700-page manual that is published every year on November 1. The last one was obviously published on November 1, 2015. This is the most recent manual. And what this shows are the different categories of offenses. We're looking at this at basically a 50,000-foot level. As I said before, there are about over 3,000 federal statutes that criminalize conduct. There is something called Appendix A to the sentencing guidelines that a practitioner can refer to that depending on what statute is relevant in the case, whatever statute the client pled guilty to or is convicted of. You go back to Appendix A, and then Appendix A will tell you what guideline to go to, what guideline that conduct is sentenced under. And again, these are rather, if you will, natural categories. You have up here the offenses against the person, homicide, assault, things of that nature, economic offenses, fraud primarily, drug offenses in Part D, drug trafficking is the big one, down in Part G, and we're going to talk about this, your sex offenses. The big sex offense at the federal level is child pornography, possession and distribution, as well as receipt. We'll talk about that. And then over here you can see some of the other ones, firearms offenses in Part K, immigration offenses in Part L, etc. So here is kind of the nuts and bolts of the guidelines. This is the sentencing table, and I'll walk you through a specific guideline, the guideline for child pornography offenses. That is a guideline and an offense category that has received a lot of attention over the last few years. But looking at the guidelines, looking at the guideline table or sentencing table, the way the guidelines work is once you go to a particular guideline, you're going to be assigned a number, and there are going to be certain factors that if they're present within the offense, you add that up. So you might start at 18, let's say, and then, as we'll see here in a minute, if there is an image of very young children, you'll get a +2, 2 levels added to your offense conduct. If there are more than 600 images, another 5 points are added, so on and so forth. So then once the judge has the final total for what's called the offense level, he or she will refer to the y-axis here, and it goes anywhere from 1 to 43, which is life imprisonment. And you can see here the ranges within these offense levels. Across the top on the x-axis, this is criminal history. I'm not going to go into this in a lot of detail, but it's pretty straightforward. The more convictions a defendant has in his or her past, the more points that defendant will receive, and the more severe the punishment will be. The theory there is if you're reoffending a lot, we need to hit you a little bit harder to try to deter you. Obviously, the first time around didn't deter you much, so we need to hit you a little bit harder to increase the deterrence. So let's assume for a second that a defendant has a final offense level of 21, and they're in criminal history 2. As we'll see here, then the final sentencing range is 41 to 51 months. Anything above 51 months would be considered an upward variance. Anything below 41 months would be considered a downward variance. Okay. So here's an actual guideline. We're going to look here at 2G 2.2. This is the primary sentencing guideline for child pornography possession, receipt, or distribution. Uh, and so, just as an example here, if you're convicted of one of these particular offenses, and there are a couple of statutes, about 3 or 4 statutes that refer to that are referred in Appendix A to 2G 2.2. You'd start off, depending on the statute of conviction, either at 18 or 22, and then you could see there's a variety of variables here that add up, uh, that are assigned particular values. So, for example, as I said before, if the defendant or if the material involved a minor under 12, you get an additional 2 levels. That's considered much more serious conduct. Over here, as I mentioned before, if you have more than 600 images, you would increase by 5 levels, and I've skipped through a bunch in here too. But the point simply is each guideline will identify important variables, or variables that the Commission has identified as important, and has assigned those variables as a particular numerical value, anywhere from a +1, +2, up to, for example, here a +5, depending on what that variable is. Now, in addition to promulgating the guidelines and amending the guidelines, another thing that the Commission does, and this is probably one of its unsung jobs, if you will, is collecting data. And what the Commission does is collects all the data, basically all the relevant documentation on every case that's sentenced in the United States each year. And from those documents, plea agreements, pre-sentence investigation reports, orders of judgment and conviction, and other documents, the Commission then takes those documents and puts it into a database. There are about 10 to 30,000 variables that the Commission has assigned for each defendant. The reason why there are so many has to do with the complexity of the guidelines, and I would just leave it at that for the time being. But because the guidelines and their application are so complex, there's a variety of permutations that the Commission's database has to account for. Now, with that said, in my opinion and the opinion of others, I used to work at the Sentencing Commission as a staff attorney, and have now been using the Commission's data files, their raw database, for a number of years. I can tell you it's a mess. It changes year to year, depending on, obviously, amendments to the guidelines, but also the format changes, the order that the variables are reported in the data files sometimes change. The definition of the variables does not change, but sometimes the Commission adds new variables, and sometimes it takes old variables away, so that can cause confusion as well too. But it's a very, very messy, user-unfriendly database. But I've used it enough now where I've been able to cull down to, or reduce it down to, about 50 or 60 variables, the most important ones that should be used or can be used for assessing sentences and doing analyses for a particular defendant. At any rate, you can see here on the right-hand side just some of the many variables in the code book that are defined, and whether they're alphanumeric, and the description for them, and things of that nature. The code book, like as I said, there's 10 to 30,000 variables, but the code book is not 10 to 30,000 pages long. It's about 80 pages long. But the reason, again, why there's so many variables is that there can be several permutations of a particular variable depending on the nature of the offense. And where it also gets very complicated is if a defendant has been convicted of multiple counts, and where it gets multiple counts, say, of fraud or child pornography or what have you, or where it gets very complicated is when the defendant is charged with multiple counts of different types of offense conduct, say 2 counts of money laundering and 3 counts of drug trafficking and 1 count of tax fraud. That's when the application can get very, very difficult to utilize the guidelines. but that again is why the database is so robust. Okay, so here's an example of just a very easy to see statistical chart that I use often either in presentations or in sentencing memoranda that I file with the court, and I'll present it at the during a sentencing hearing. But this is a very simple one, and it's not very robust. But what this shows you, just as an example, is I spoke earlier about the change in the guidelines going from mandatory to advisory. That happened in 2005. So nowadays I only look back to the beginning of the advisory universe was really in 2006. Data before 2006, because it was in the mandatory era, is not very helpful to look at because it can be because it was in the mandatory era. I think the era things were treated differently back then. But now in the advisory era, what's really interesting to see is how the guidelines have decreased, or how the compliance with the guidelines has decreased quite dramatically. And it's not surprising because what Booker said again was that judges now have more discretion. If they disagree with the guideline range, before, too bad, so sad, so to speak, you had a sentence within. But now, they can exercise their discretion and sentence below or above the guideline range. By the way, sentences above the guideline range are exceedingly rare. Pretty much all variances, if there's any variance, it's going to be below the guidelines. And then the question becomes how much of a variance below the guidelines. And the statistics can report on that too. But so here, if we look at the blue line, we can see it's gone from a compliance rate of above 60% to now below, less than half of all sentences are within the applicable guideline range. What the red line indicates, these are what are called motions for substantial assistance. This is the rate of below guideline sentences as a result of a government motion because of a defendant's cooperation. For example, two defendants in a drug trafficking conspiracy, defendant A may decide to turn, as they say on TV, state's evidence against defendant B. And if the government feels that his cooperation was useful and helpful, the government can, on its own, move the court to sentence the defendant A below the sentencing guideline range. So that's called cooperation. But the government, importantly, has the discretion to do that, not the court. But for pretty much any other reason, the court, though, can, on its own, sentence below the guideline range. And that's the more interesting one. And this is the green line here. So you can see as the compliance rate has gone down, the below guideline sentences obviously have gone up here in the green line. And again, this is just overall. You can see they've increased from about 12% to about 21, 22% now. Basically, 1 out of every 5 sentences the judge is sentencing below the guideline range, just utilizing his or her own discretion. So now if we look at a particular offense category, it's dramatically different. That prior slide was overall. Now looking at this slide, this is specifically for child pornography offenses. We saw the child pornography guidelines earlier, 2G 2.2, and here you can see that the compliance rate was very high, 65% higher than the average or the overall compliance rate back in 2006, and now just less than a third are sentenced within the range. Again, here the red line, these are indicates government motions for substantial assistance. The real telling line, though, is the green line, where you can see the where judges have sentenced below the guideline range based on their own initiative, their so-called Booker discretion. Generally, when judges do sentence below the guideline range, it's because they perceive that guideline range to be too high. It's overly punitive. So this is why, frankly, statistics are important. Many judges aren't aware of this. As a matter of fact, the commission does not publish, while this data is taken, or this table is taken based off of sentencing commission data, the commission doesn't publish a table like this or a chart like this. And this is very telling. Judges always, eyebrows go up. Oh my goodness, I didn't realize that so few judges are following this guideline range. Maybe I should think twice or real hard before I decide to impose a sentence within this range. And just a quick tangent. Traditionally, the way uh, uh, defense counsel, and I still see this today, but the traditional way to uh, argue that a particular sentence was too high is defense counsel will just go out and just grab an ad hoc collection of 5, 10, 15, 50 cases, just using a Lexis or Westlaw search, and find a bunch of cases, create a literal table, United States versus Doe, received 25 months in this case for this conduct, and then they'll just have a whole list and all this other stuff. Well, the problem with that approach, as one could easily, or one could imagine, is the government could do the same thing. The government could go out and get, which the government always does in a case like that. Government goes out and gets its own ad hoc number of cases to show why the sentence that the government is suggesting is fine. That other people get a sentence like this, or they get higher sentences. And so, at the end of the day, though, the judge is left to just compare two ad hoc tables, and who's basically it's a test on who's the better researcher, or really if they mean anything. Because what kind of if to use Johnny Cochran's terminology, garbage in, garbage out. So here, by using the statistics, you can grab the entire universe of cases, and there is no ad hoc, there is no ad hoc nature to it, at least in the sense of the database, the data file. You can grab, if you wanted to know, for example, and we'll look at this in a second, everybody that received a final offense level of 33 in criminal history 4 for fraud that was sentenced under 2B1.1 that pled out. You can get all those, you can control for all those variables. Then you can tell the court exactly what the average sentence was, or what the median sentence was, or even what if the government's proposing a very high sentence, what the percentile of that sentence would be. Your Honor, the government is, as we'll see here in a minute, proposing a sentence that's in the 89th percentile, meaning it's higher than 89% of the people who were in this exact same category as my client received. And so that, again, very, very compelling to a court. And it's really going back to the roots of the guidelines. Okay, so here's another interesting chart, too. Again, just looking at child pornography, but also comparing among offense categories. This just compares among all these major offense categories the rate of downward variances, court-initiated downward variances, or what I call here non-government sponsored below guideline sentences. I probably should change that to something a little bit less clunky. But at any rate, you can see here in 2006, 20.8% of the sentences for child pornography were sentenced below the guideline range as a result of Booker discretion. Now it is more than doubled. 43.6% are receiving that. This is powerful, too, by comparing to other offense categories, so courts can really understand if, just as an example, you're looking at if your client is a child pornography offender, then you could show the court, look, Your Honor, this is how crazy this 2G 2.2 is. Nobody's following it. Very few people are following it. And there's something wrong with it when you compare it to other offense categories. Now, I've used that same argument, though. You can get rid of this, the child pornography, and just make that same argument, for example, with fraud under 2B1.1. This shows the dramatic increase in downward variances for sentences under 2B1.1, the fraud guideline, and so on and so forth. By the way, these are the major offense categories. All these, obviously, overall, but these categories right here, taken together, constitute about 85% of all sentences under the guidelines. Okay, so now the next slide here, and this is also very interesting too. But this you can show the court where average sentences have been going over the last several years for a particular guideline, if that was relevant to your presentation. But here, just again, as an example, you can see that the sentences for child pornography offenses have gone through the roof. They're a lot higher on average than any other major offense category. And what's really interesting about this is, as we saw in the prior slide, the rate of downward variances below guideline sentences have increased dramatically. Yet, ironically, the average sentences keep going up. You would expect just the opposite. Well, what that is telling you, and what that tells the court, is that the guidelines are so, for child pornography offenses at least, are so off the charts that courts can't correct for it quickly enough. Basically they can't correct for that quickly enough. They're not very. They either need to vary more often, or the degree of the variance isn't significant enough to correct for the god awful nature of those guidelines. And they are crazy when you're looking at 154 months as your average sentence compared to drug trafficking and firearm offenses and other types of offenses. And again, by the way, these offenses, a child pornography offense, none of them are contact offenses. This does not involve an actual child. There's no child molestation going on. It's primarily individuals who are caught trading pornographic images on the internet. So that what you could also do is take these average sentences and compare them to what somebody who has committed an actual child sexual assault in the state might receive. And that's when it gets really dramatic too, because in most states, child sexual assault may get you just probation on average. Or you could compare the child pornography sentences at the federal level to child pornography sentences at the state level. Just as an example, in California, a first-time offender for child pornography possession can expect probation, whereas here they're going to be looking at over a 10-year sentence, over a 12-year sentence. Okay, so now let's look. Here's a rather simple chart that I used recently in a child pornography sentencing memorandum. What this shows here is the defendant in this case, his final offense level was 33. He had pled guilty, and he was in criminal history category 1. He had no criminal history, in other words. His guideline range at an offense level of 33 was, let's see here, 135 to 168 months. So going back to this, the government was arguing for a 151-month sentence, which was within that guideline range, and we were arguing to the court for a 60-month sentence. And one of the things that we showed the court, we didn't, even though we're arguing for a 60-month sentence, by the way, the reason why we're arguing for 60 months is that was the mandatory minimum. There are some types of offenses that carry what are called mandatory minimums, primarily in drug offenses. That's what we're most familiar with. But some child pornography offenses also carry a mandatory minimum, as do some types of fraud. So at any rate, this was the minimum the court could give the defendant in this case. What I was able to do is I looked at all defendants sentenced under 2G 2.2 from 2006 through 2014, which was the latest year that the data files have been publicly released. And their final offense level is 33, criminal history category 1, pled guilty. So everybody, in other words, that's not just similarly situated, identical to the client for purposes of guideline application, at least. Now, every client is different in the sense that they may have different backgrounds, different education, and other things. But for guidelines purposes, all the variables that matter for the guidelines, they're identical. The average or the median sentence for those individuals was only 90 months. And so what that means is the median sentence was well below the bottom of the guideline range for an offense level 33. At the bottom of the guideline range was 135 months, but these individuals, the median was only 90 months, so well below the bottom of the guideline range, which would have been approximately right up here. So just in this particular case, unfortunately, as I had mentioned, sometimes clients will have, there is a difference that can't be captured by guideline variables. There are other soft factors in a defendant's background, and fortunately this defendant had some very bad soft factors, and he ended up getting what was very, very rare, a sentence even above the guideline range. He ended up getting 181 months. But that was the only case actually in my career where the statistics did not help. But that, I don't think anything could have helped this particular defendant. At any rate, let's look at one more. Here is a more robust, and excuse me, I'm sorry, I don't know why this stuff is in there. Oop, here we go. Maybe I can get that out. Make it a little bit cleaner. Okay. So this is a more robust sentencing chart. This was used actually a few weeks ago, actually a week and a half ago, in a fraud case that I worked on, and it helped. This, unlike the prior client, it really helped here. This particular client, he was a repeat offender. He was in criminal history 4, which is pretty significant, and his final offense level was 18. We actually argued that it was 16, but the court found that it was 18. And the bottom of an 18 in criminal history 4, if we look at this, is 41 to 51 months. So that's what the government was arguing for, a 41-month sentence. As it turns out, just interestingly enough, this defendant had sat in prison or jail for 44 months prior to his sentencing for a variety of reasons. It's not worth going into, but that also was highly unusual. As a matter of fact, I've never had a client like that before. But he sat in prison for 44 months before his sentencing a couple weeks ago. He was released, I think, in November. At any rate, he was released before sentencing, and really what our argument was, look, Your Honor, he's already served enough time. He's already served the equivalent of a 53-month sentence. 53 months, if you take into consideration good time credit, some other credits he was entitled to, he would have only served 44 months. So he's basically served a sentence above the guideline range that even the government called for. Remember the government's guideline range here was 41 to 51 months. So at any rate, what I argued here was I said, look, Your Honor, in an offense level, final offense level of 18, bottom of the guideline range is 41 months. However, I looked at all the defendants from 2006 through 2014 sentenced under 2B1.1 that were in criminal history 4, okay, and this is a typo here, that should be 4, just like it is up here. But anyway, criminal history 4, that pled guilty just like this defendant, and again, final offense level is 18. The average sentence was only 38.4 months, below the 41-month guideline minimum. Same argument here, but we lost this argument saying that his final offense level is 16, and that's why it's color coordinated, the green and the green, yellow and the yellow. So at any rate, that's what we argued to say, look, Your Honor, he's already done a lot more than what he's done essentially about 60%, or excuse me, he's done a lot more than what the average defendant in this criminal history category would receive normally. Under this offense level 18, criminal history 4, the average person will only do 38.4 months. The government's arguing for 41 months. He's basically already done 53 months. Keep him out, time served, no point putting him back in. Court agreed and had a very happy defendant because of his criminal history and a lot of shenanigans he had pulled. He was actually very lucky, but the court agreed with this. But anyway, so this is just by the way, I should add these blue columns here. These are other offense categories that sometimes help to compare your client's sentence to what the averages are in other offense categories, to give some type of perspective to the court on how serious these are. Sometimes it's not enough to say, this is a really serious fraud offense. But for example, here I added in the average sentence for aggravated assault, which was 58 months, to make the point that, Your Honor, he has already served a 53-month sentence, which is almost equivalent to the average aggravated assault. That's a physical offense. And to commit aggravated assault, by the way, federally, it's not just assaulting anybody; it has to be a federal officer. So that's very serious. He's basically served a sentence not only that's greater than or far greater than what the average person that's similarly situated to him would have received, but it's almost as much as what somebody facing aggravated assault would receive, and more than bribery. I threw this in because that's an economic offense. He committed an economic offense. An obstruction of justice. There was questions about his that he may have obstructed some justice in his case. And I just noted here that the average sentence was only 33 months for somebody also in criminal history 4. So all that's that's rather compelling to a court to take all of this into consideration in determining whether to sentence within a guideline range or below the range, and if so, how far below. And that basically is how the statistics can be used and how they operate. So that ends the presentation. Of course, if there are any questions, please feel free to call me or send me an email, mark@allenballlaw.com.